Hello, everyone. Thanks for joining us today. Either it's your morning or your evening, depending on where you're joining us from. So I am very, very pleased to introduce you all to what will be an enthralling discussion on Sandipto Dasgupta's book, Legalizing the Revolution, India and the Constitution of the Post-Colony, published by Cambridge in 2024. The book is, I think it's a phenomenal addition to a series of disciplines. It contributes to post-colonial studies, obviously Indian constitutional law. It also contributes to our understanding of decolonization and most importantly, and which is why we're discussing the book here on the Modern Criminal Law Reviews Forum, it intersects and interrogates the idea of state power so wonderfully and contributes to thinking about criminal law in the Indian context as well as in the larger post-colonial context that makes it really essential reading for anyone interested in these conversations. So without further ado, let me just briefly introduce the panelists, although they don't really require too much of an introduction anyway, and also to lay down what is going to be the format of this next 1.5 hour conversation. We have the author with us, and he will first lead us through a basic introduction of the themes of the book, and obviously, that core idea that makes it so relevant for discussing it on criminal law forums as well. He'll be followed by Gautam Bhatia, Dr. Gautam Bhatia, I should say, who is a lawyer and an academic. And also when he doesn't wish to be either of these, he wears the hat of a very successful and well-published science fiction writer. Following Gautam, we have Professor Anuj Bhuwania, who's a professor at the Shiv Nadar Law School, should I say, or Shiv Nadar University, I should say, in Chennai. And following that, we'll have Professor Arudra Burra, who's a professor at IIT Delhi. And then finally, to round it up, we have Dr. Aparna Chandra, who's a professor at the National Law School of India University, Bangalore. And without any further ado, why don't you take us away, Sandipto? Sandipto.
Thank you. Thank you, Abhinav, and thank you to all of you for doing this. This is a situation where this panel, I think every single one of you are quoted in the book, and I learned a lot from your work. So it really is a privilege and a pleasure to be able to discuss it with you. I just want to set out the book is long, unfortunately, and has many different things going on. So I'll try to sort of really summarize the very, very, very core bits to start the conversation. So I think maybe it's good to start with sort of the methodological part of this. I went to a law school. I was a law student. And the way we were trained to read the Constitution or the constitutional debates generally is to sort of scan them for some coherent legal principles as a juridical text to give us certain principles. This is the Indian idea of freedom of speech. This is the Indian idea of rights of property, and this is how the courts have interpreted them, and so on. And that's the first point where I wanted to depart, which is, to me, the Constitution was sort of a contemporaneous record of a particularly interesting task on which not a lot has been written upon, which is you had in the 20th century, from the beginning of the 20th century, but also especially from First World War onwards, these mass anti-colonial struggles across especially Asia and Africa against empire. Those struggles sort of came to fruition after the Second World War, and we get decolonization and independence, right? And after independence, the real challenge is how do we translate this expansive promise and hope of anti-colonial struggles into post-colonial institutions? I think it's a particularly fraught and interesting challenge. And the constitution-making process and the assembly debates can be read as a record of that particularly fraught challenge. And if we read like that, then we have something which I think is also sadly has not been very common, which is to bring together the history of decolonization globally and the history of or the study of post-colonial constitutionalism. Because normally one is left for historians and political scientists, the other is for lawyers, right? And I thought that these two things needed to be brought together. So that's the main sort of methodological departure. I think a lot of the book follows from that task of reading the Constitution like that. I'll just highlight sort of two maybe main core points, because if you are reading it like that, then firstly you get the history of decolonization tells you something about post-colonial constitutions. And conversely, post-colonial constitution making can tell you something about sort of the political theory and history of decolonization. So, both of them contribute to our understanding of the other. And on both those axes, let me make just one core point to set this up. On the first sort of axis, the axis of what does constitution making tell us about decolonization, the history of it. To me, what was the most interesting question there is trying to map the distinction between, or the divide, if there is one, between the anti-colonial and the post-colonial, right? And to me, the central divide was that the question of popular politics, both conceptually, the people as a sovereign and so on, as well as practically with the Gandhian mass movement, was absolutely central to the anti-colonial cause. You cannot have an anti-colonial cause unless you conceive of it and practice it in terms of popular politics, right? Because as I said in the book, the empire can give you many things. The empire can give you more rights. The empire can give you economic developments. The one thing no empire can concede is popular government, right? So the people had to be the central antithesis of the imperial cause, right? And that, my argument was, so this nature of the anti-colonial movement being this mass movement, bringing the people as a political subject onto the scene, the fundamental distinction for me and the constitution making process was this simultaneous dependence on the people, because they are the basis of which you're claiming independence, as well as anxiety about mass movements, because they tend to radicalize, generate demand, which is far more than what the elites would have countenanced. And so what you get in the constitution making is quite a deliberate distancing of the institutional structure from popular politics, not the people as a concept or some kind of a divine entity, but really of the nature and the forms and the processes of popular politics. And that separation, to me, was quite foundational for not just post-colonial institutions, but the post-colonial political life. You can sort of tell a story about how post-colonial political life sort of develops after this, not just in India, I would argue more broadly across the post-colonial world, due to this foundational separation. So this kind of, and that to me really set up this distinction within the anti-colonial and the post-colonial. On the other hand, of what can decolonization tell us about the constitution, the short point there was to say the term I try to use, called transformational constitutionalism. It says basically two things. One, that because of the nature of this flux of this popular movement and aspiration, which went far beyond just the formal political independence to some kind of, amelioration of massive sort of social inequality and poverty and deprivation, right? The constitution makers saw their task, their primary task, as what I call in the book revolution without a revolution. In other words, to make quite ambitious project of social change, but in a gradual, controlled, planned manner, right? So to have kind of a revolutionary change in society, but without the revolutionary upheaval, right? Uh, and both sides of this is important for us, because on the one hand, what this gives us, I think, is quite distinctive from what's the traditional sort of the US-centric constitutional theory which we get and which we often adopt for our purpose in India, which is constitutionals are meant to be some kind of an abiding order, right? They're going to give us something which is going to preserve it for the rest of time. Except the core principle, the orienting principle for the Indian constitution making project in their own terms, on their own terms, of the constitution makers was change, controlled change, right, or transformation. But on the other hand, that transformation had to be done in a way which did not lead to mass political upheaval or mass mobilization for that matter, right? So this nature of a transformation, which is quite thoroughgoing, so that's the constitution wants to mediate that, nevertheless kept separate from popular politics, becomes, I think, the kind of the animating or the orienting sort of principle of post-colonial constitutions, distinctive from the earlier ideas of constitutionalism, which we often get in Western thought, right? So let me sort of end with a couple of few things in terms of the topic for today, in terms of criminal law, right? Why all this matters at all for criminal law. And I will just say two things to that. One is once you kind of imagine the project of transformation and constitutionalism around this idea of planned transformation, the key entity becomes the state, right? The state is the entity which the Congress would inherit and would use as an instrument for this project of controlled and gradual social change, right? And it is this centrality of the state in the constitutional imaginary, or even the post-colonial political imaginary, I think, which gives us a particular, relationship with both popular politics as well as criminal law, right? So the state being the central entity, um, as opposed to, you can think in terms of the, let's say, popular political forms or parties or parliament, the state itself, the executive state, being the central entity, I think gives us already something distinctive in terms of how the state will deal with social disorder. Because if you think of crime, that is basically forms of social disorder, and the way we try to deal with that as a society, as a polity, is what the criminal law does, right? The second element to that would be, therefore, the techniques and interventions in terms of how we imagine crime to be and how we intervene in that, what kind of punishment, what kind of processes we follow for that, is drawn a lot from what I call this sort of administrative disciplinary vocabulary, right, which was there in the colonial state. It's distinctive from the idea of rights that we often get in the Western constitutional theory, and which many liberal Indian constitutional theorists have adopted for good reason, for good political reasons. But nevertheless, that imagines that there are these certain clear lines which are drawn, and beyond that, the individual or the citizen has these inalienable rights, right? Kind of in a kind of a natural law, or this core rights of Englishmen kind of way. I think that really works for Indian Constitution to understand the rights section. I think it is really about sort of moderating, curating parts in which a person or a citizen can participate in public life. That's what really the rights section does. It's more about curating and moderating rather than laying down clear guidelines and guardrails. Right. What that means, therefore, is that the rights section has to be understood as part of a larger repertoire of both, giving certain rights as well as repressing certain kinds of behavior, which the state brings along to curate this process of moderated, mediated transformation, right? And so rights and repression, in that sense, I argue, goes hand in hand. And that's a lot of peculiar things about Indian criminal law, both in terms of practice and theory, I think would be explained by that. For example, why does, again, not just in India, but broadly in the post-colonial world, criminal law becomes a routine instrument when dealing with political dissent, especially non-electoral political dissent, right? Because it is part of this larger project of disciplining and shaping public participation in politics. Right. So I think that's a different way of thinking about it than often the way we think about, which is that India wants to have rights, but we somehow don't really get there, right? There is sort of, there's a lack or a gap in the way we try to approach of rights, especially including rights for defendants in criminal cases, right? So that's the sort of, broad kind of outline. There's many more details and things in the book, which I guess can come out in the conversation, but I just want to set the conversation up like that. Thank you.
Thank you so much. And yeah, just to sort of make that very clear for the audience, there are several themes of the book that unfortunately won't be sort of really discussed by the panelists, especially like I would want to flag, the discussion on the right to property, which is like a really comprehensive discussion and a really critical discussion for the arguments as he's developed them in the book. So really encourage everyone to sort of go out there and read them and engage with them for yourselves. Without anything further, then Gautam, why don't I hand the floor over to you for
Yeah.
sort
Am I audible? Is it right? Yeah.
it's
Thanks. So thank you so much for inviting me to speak. Abhinav began by mentioning science fiction. One of my favorite novels is Marlon James's Black Leopard, Red Wolf, and there is a line in that novel where there is someone, a sheriff or who's coming, and someone says, "Well, here comes the man of justice," and someone responds saying, "No, here comes the man of order." And those are two fundamentally different things. And I think that if we were to, really crystallize the last 75 years of the Indian Constitution, specifically its intersection with criminal law, in one sentence, that is the sentence that I would choose. I read there are books that are wonderful books, and this is a wonderful book, but there are also books that you sometimes, by good luck, end up reading at very important times in your own intellectual life. And so I was also lucky to read this book at a time like that, when I was really grappling with, just after many years of practice, just the question of why there exists this massive gap between what the Indian Constitution appears to promise and what in public life we all seem to believe that it has always promised, and outcomes in courts. And it seemed to me that you always begin, when you notice the gap for the first time, you tell yourself that this is just bad judges, just not understanding the Constitution or not interpreting it correctly. These are authoritarian judges who are giving vent to their authoritarian impulses, and in that way, in a certain way, are betraying the promise of the Constitution. And we could solve these problems if only we just got better judges who really got our arguments and engaged with them properly. But at some point, you begin to feel that there is something missing in this argument, and there's something more to it. And I was in many ways trying to ask myself what that something more was, and that's when I read this book, and a lot of it made a lot more sense at that time. So I think that what I would like to say, and this is where I think the intersection between criminal law, the Constitution, the framing of the Constitution, all comes together, which is understanding the Constitution in terms of what some scholars call power maps, which is to say that how does the Constitution look at the question of power, not just state power, all kinds of power. And One very common argument, of course, is this whole debate about is the Constitution colonial or not. And you often end up really getting into the weeds of this by saying, look, this is what the Constitution borrowed from 1935, but this is what it didn't borrow. So, and then that debate goes on. I think one very important perspective-altering thing that this book brings forward, and it's at some point in the book, I don't remember the exact quote, but the point is made that the things that you see that are taken from the previous pre-independent legal instruments are more the effects of something. Then they're not like they themselves are not colonial continuity, but they are the effects of a certain kind of philosophy or a certain kind of understanding towards power and who wields power and upon whom is power wielded. And so it's best to understand them as products of that and not themselves being the examples of colonial continuity, which to me really represented a way of breaking out of what had become a very sterile debate. Now, the way that applies to criminal law. So let me begin with an example, and this is something that I've thought about a lot, and it's a question that I ask some of my students when I teach the A.K. Gopalan case. So I teach this course on the Supreme Court's first 20 years after independence, and I begin with Gopalan. And of course, like as everyone knows, Gopalan is the case where the constitutionality of the preventive detention law at the time was upheld. It was the first really major challenge to the long-standing practice of administrative detention after independence. Now, as we all know, the Supreme Court upheld that. There was a 4-2 split on certain issues. One provision was struck down, the rest were upheld. And of course, there is some confusion about what the court really held, whether it actually held that the rights are meant to be understood in silos or not. Let me for a moment put that aside. To me, and this is the question I ask my students, what I ask them is that when you read Gopalan's case, you read all the judgments. Is there something that strikes out or stands out to you? Not something that is said, but a silence. And for me, what is striking about that judgment is that the judges borrow from all kinds of sources. This is the first major judgment of the Supreme Court, right? They borrow from the US, they borrow from the UK, they borrow a little bit from other countries, from a little bit from Ireland. They look at a little bit of the framing debates. They look at Privy Council cases. What is striking by its omission is that there is no reference to the freedom struggle. So like the freedom movement and the fact that you were the detention without trial was really something, a fundamental weapon in the colonial armory. It was something that our freedom fighters struggled against repeatedly. Civil rights rights against the detention were part of the vocabulary of the freedom movement. All of this, and that this might possibly play a role in now interpreting Article 22 of the Constitution, it just does not seem to figure in the imagination of the judges. The question then, of course, is why? Why does it not figure? And that's where I think the book really gives us an answer, which is that the dominant philosophy of the Constitution was always the philosophy of order. And the state was the central normative object of concern in the Constitution. We love to cite Ambedkar saying that, oh, like the individual is, like the fundamental unit. I'm so glad, it's not the village but the individual. But, really, if you look at the Constitution, look at the framing history, look at what went up to it, really the unit of the Constitution is the state. That is the fundamental object of concern in the Constitution, not the individual. And that shows in a judgment like Gopalan, because literally 3 years after independence, it seems that there is a complete erasure of the struggles that really gave rise and gave birth to the Indian Constitution, and those struggles play no role in interpreting it. And it's striking to me because when I read a judgment from, say, the Kenyan Supreme Court on criminal law, it is full of the references to the way that the Constitution was framed, the popular movement, what led to the Constitution's framing. I read South African judgments, it's full of anti-apartheid, the struggle, like what led to the Constitution's framing. And the Constitution is responding to apartheid. It's all there. Even US judgments, from the early days, you look at it is informed by whatever movement they were having, which led to their so-called, freedom at that time. That sense of history is completely missing when you interpret the Constitution, its criminal law provisions in Gopal. What is even more striking about Gopalan is not just the silence, but in two of the judgments, you see this explicit reasoning that, look, detention without trial was this fundamental aspect of Indian criminal law prior to independence. And if now we were to interpret Article 22 in a certain way, which is the way Gopalan wants us to interpret it, it would just completely overturn the CRPC. It would overturn these fundamental principles of the IPC and the Evidence Act, all of that. And we really can't have that happening. So the approach of the court in Gopalan is that the normative default or the normative baseline was the existing criminal legal structure that was there in the colonial era. And the Constitution is meant to sanctify and to preserve that structure. So it's not that you interpret the Constitution autonomously and ask if the existing criminal legal framework now meets the standards of this new Constitution that we have, but basically it is how do we reconcile the Constitution and existing criminal law, which obviously means interpreting the Constitution downwards so that the Constitution can then comply with criminal law, not the other way around. You see this not just in detention cases. You see this in Article 20, self-incrimination, double jeopardy, all of that, and Abhinav has written extensively on all of that. So basically, wherever you see the early Supreme Court interpreting the interface between criminal law and the Constitution, which Gopalan is the starkest example of, the dominant philosophy is that the Constitution is meant to preserve the existing colonial criminal legal framework. And it's not that we must now ask ourselves that this Constitution, which was the product of the freedom movement, how do we understand this in that sense? And then ask the question, does criminal law measure up to it? That's not the inquiry going on. It's basically how do we preserve criminal law? And in that sense, I think the argument is that there are really strong colonial overlaps or echoes in the Constitution in the sense of what kind of power map does the Constitution set up. And I think that the book, what it does is it gives you insight or gives you a path into that map by telling you that ultimately the way the Constitution was framed, whether it was property and land, which I agree with Abhinav. For me, the most fascinating chapter was the property and the land chapter. It's just full of annotations, and I'll be teaching that chapter, in fact, in 3 days' time. But whether it's land and property, whether it is criminal law, whether it is free speech or rights, basically, ultimately, you perceive the Constitution from the lens of the state. And that then really tells you a lot about both the initial days. It also tells you why ultimately, not to find appointment, why we lose all our cases against the state, because we are really, like on a terrain which is like sees the state as the fundamental object of concern. So I will stop at that point and hand over to the next speaker. Thank you.
Thanks, Gautam, for reminding us, or rather reminding the rest of us, what my usual fate in my day job is like. Just a couple of things before I hand the floor over to Anuj, because I just got a question from some interested viewers. Please feel free to post in your questions on the YouTube page where this is being live streamed. And in case, it's open, just please go to the relevant link. It's been put out everywhere. So all yours, guys. And just another thing, because Gautam, you mentioned it. It would be amazing if you can sort of give us references to other sci-fi books that sort of tap into these themes, because I have read that Marlon James book and it is absolutely brilliant. So without wasting any more time, Anuj, please, floor's all yours.
Thank you, Abhinav, and thank you, Sandipto, for giving us this chance, give us opportunity to engage with your work. So this is, of course, a tome. It's more than 500 words, 500 pages. There's a lot there, a lot of ideas, a lot of themes there. So what I'm going to do here is just focus on 3 or 4 key analytical, themes that he particularly, works with. So I actually have a PDF version of the book, and actually, I just was looking for this word colonial, and I found there were more than 600 times that this word was used in this book. And I was just trying to understand what is the idea of colonial that is being worked with. As Gautam mentioned, the term colonial and decolonial is very much in vogue, in controversial terms, especially in this country. So I was just trying to understand what is this category of colonial here, right? Because Sandipto talks about the cabinet mission plan as a colonial project, but he often reverts back right down to Battle of Plassey. So we're talking about a 200-year time span, and it's not clear how to think about this time span. There was this article published more than 25 years back by David Scott, which is a critique of Partho Chatterjee's very popular idea of rule of colonial difference, where he spoke about the fact that the idea of colonial needs to be historicized, right? So he spoke giving the example of Sri Lanka, talking about at least 3 different phases of colonialism, of British colonialism in Sri Lanka. Of course, Sri Lanka had the misfortune of having even further, colonialism going back to other colonial powers. But anyhow, so I think it's important that we think about this question, right? If we start talking about the cabinet mission plan as colonial just in the same way as some events of the late 18th century, it's something to think about critically. Because what I saw in a chapter on I think it was a chapter on Parliament, where Sandipto spoke about this idea of the Indians not being ready for self government, and tracking it to Mill's, John Stuart Mill's famous final chapter in his representatives of on considerations on representative government, and how he famously said that Indians are not fit for for self-government, and the famous waiting room of history example, and the metaphor that Dipesh has made famous, Dipesh Chakraborty, and Lord Dufferin's statement in the 1880s along similar lines, right? That Indians are not going to be ready for self-government. But on the other hand, we have two other famous statements, one by Lord Montagu in 917 and one by Viceroy Lord Irwin 930, which explicitly talks about the pathway to dominion status or self-government of a kind, right? So what we see is that if we start quoting developments from a different era to talk about the colonial from let's say the late 19th century, discuss something that happened in the early 20th century, it would lead to difficulties. There's another word that is used a lot in this book, that the word is masses. I counted there were more than 400 times this word was used in this book. And what we see here is that there is this idea of, the masses are in a sense in a sense, spoken of in two ways. One is the ethnos, one is the demos, and demos as the people, right? And this idea underlying that is the ethnos is ethnos bad and demos good, right? That idea that that what it does, unfortunately, is that when we start, each time what we find is that Sandipto talks about the ethnos, it immediately becomes about the colonial construction of the ethnos, right? It's a kind of a version of the more recent post-colonial version of the old divide and rule, thesis, which is that, so for instance, I'll give you an example from the way he talks about states and minorities. The instance where he engages with Ambedkar's ideas, where he says this was not a familiar iteration of the minority question with regard to distinct religious or ethnic groups in need of special legal protection. And he proceeds to call it an infamous alibi of late colonialism. Now, interestingly, if you go to states and minorities, this is how Ambedkar himself addresses this argument. By the way, this book is explicitly, the States and Minorities is explicitly a book about the minority status of his community and the question of rights of minorities, right? And in the terms that are in terms of the familiar, infamous alibis of colonialism, like separate electorates and such like, right? So he's explicitly making an argument for reversing the Pune Pact. So so instead of just finding this kind of a proto-communist Ambedkar there, what we find is that he is very much a spokesman for the ethnos there, right? So what we find is that he says, for instance, about this argument, he calls, this familiar argument, one can say, that separate electorates enables British imperialism to influence the communities having separate electorates to act against the interests of the country. This is how Ambedkar talks about it. He calls it, this argument has no force. It is nothing but escapism. And in fact, now the Brits are going, this excuse that the Congress have had against it can go, right? So it's important that we understand that the question of heterogeneity of the masses have to be dealt with, right? Who are the masses? Do they have a caste? Do they have a religion? Do they speak any languages, right? So that's something which is repeatedly elided in this book by this colonial trope that we see, So what we see then, for instance, there's another point where he argues that the same Mill's famous argument in the final chapter of Considerations in Representative Government, to talk about the fact that so while that is being spoken about as a kind of colonial justification, there's another colonial justification for lack of self-government in India is its heterogeneity, right? But these two questions, the Mill's kind of ethnocentric point of view with regard to the lack of preparedness of Indians for self-government, and with the question of which he has in another chapter of his book, which is on the whole question of tyranny of the majority, a kind of an endemic problem of democracy, right? So this kind of, he has this chapter on, so what I'm trying to say is that if we keep blaming the question of the ethnos as purely a result of the colonial construction, instead of facing it, as it was, the central political problem, the Indian problem, as Reginald Copeland would say in this period, in the 20s and 30s, it's a kind of an attempt to kind of evade the deep heterogeneity of this place. And that takes me to the third term that is important for us, which is the term India itself, right? What is the idea of India that Sandipto is working with? Now, this is a determinedly pan-Indian book, right? So, I can talk about three different planes in which this can be spoken about. So, the idea of, when did India come into being? Is it British India? Is it, what is this idea of India that we are working with? Is something to think about, because even we talk from the late Congress point of view, the Congress, of course, had many cleavages which are provincial, right? So the Bengal Congress and the High Command famously were at loggerheads repeatedly. The Bengal Congress famously presented something called the Bengal Pact, which was defeated by the Central Congress. Then there's the high command culture of Congress, which we are familiar with now, but it was already seized upon by Jinnah back in 1940 in his Lahore Resolution speech. So so this problem of the idea of India that we are working with is already there. So that is one. The second problem with regard to that is, of course, that in this late colonial period, while the question of representation of groups is one central political problem, right? The other central political problem. So one problem is of consociationism, of sharing of power between communities. The other is of federalism, and they're actually quite closely tied with each other, right? So, so right from the 1920s, we see the Muslim League demanding, federal, kind of a really strongly federal state as opposed to the strong center which Congress insists on. And that it comes to a head on the Nehru report, where when you see the Muslim League demands are explicitly on question of federalism, right? So we have to keep in mind that Congress, had working with the pan-Indian imagination, but Congress itself had these issues within, and itself, by the 30s, for instance, Congress was actually quite weak in states like Punjab and Bengal, right? In the other parties which were there. Then there's a third problem, which is that there's a kind of a inevitability to the idea of India as it came to exist in 1947, which particularly manifests in examples of princely states, right? So the idea that in the 40s was a time of alternatives, as Sunit also talks about, kind of ways of imagining different territorial entities, different forms of sovereignty, different divisible sovereignty, as Priya Saxena's book has spoken about. And that is completely elided again. For instance, if you speak about, the princely states are in a sense a cartoonishly, reductionist figure here. And a process like what happened in Manipur, for instance, right, where you have an alternative constitutional structure worked out locally, with providing for a complicated consociation sharing of power between the hill state, between the hill and plains region, that is not even something that the analytic that we have here. I don't say that every example has to be dealt with, but the analytic that we have here has no place for an example like Manipur, right? Because the alternative that he talks about here is that there could be a popular mobilization, right? So that question of popular mobilization is the only way to imagine the alternative, right? As opposed to something as complicated what we see in Manipur. So so what happens is the question of heterogeneity. We know by now that the Congress, while it spoke in the name of the people, now, there's this famous example, as from the sites of Gandhi's infamous intervention in the Second Roundtable Conference, where he claims that Congress is the only representative of the masses, right? Now, this is, of course, a central question in this period. But the political scholarship of this period has shown to us that actually Congress had ceased to represent Muslims for sure by the 30s. We're talking about somebody like Jan Pandey writing this book, which actually Sandipto cites, called The Ascendancy of Congress in UP, where he says that that common Muslims, no less than their elite leaders, came in most provinces to stand apart from the Congress as early as the 1930s, right? And of course, he talks about UP in detail, and we have Joya Chatterjee's work to talk about Bengal, and how Bengal Congress was pretty much indistinguishable from Hindu Mahasabha, right, in the 1940s. So we see that the categories of the people of the masses, etc., breaking down. And so what I wanted to underline then was that if we are trying to problematize the state form, right, if the attempt is to problematize the state form, we cannot not question the nation form. And I don't see that happening here, right? The nation form is always already there in this analysis. India is already there, perhaps, even in Battle of Plassey. I mean that idea of India that we are working with is interestingly already there. And it is particularly ironic because we have this discussion here of the breakdown of empires leading to complex forms of sovereignty emerging, right? So and now, of course, there's a lot of work on Habsburg and Ottoman Empire, and what happened with the kind of with the state forms and the nation forms emerging there, right? But in this British Empire in South Asia, we assume that India is just a successor to British India, right? There's no way to problematize that relationship, right? There's no way to think about that relationship critically, right? It's an interesting problem that is kind of a deep-seated nationalist way of thinking about this history, right? So my question then is that if we do not begin to question the nation form, right, how do we even even make sense of this, of what was going on in this period. Because after all, if we want to understand the politics of the period, we cannot not engage with the ethnos, right? So yeah, and therefore, to imagine that the alternative to the Congress was just the masses, some idea of some inchoate masses, which could or may have been represented by the socialists or the communists, right? But there's no question of the League or the Scheduled Caste Federation or the Justice Party or the Hindu Mahasabha, right? Because all these four parties are, of course, ethnos, right? So there's no question of any engagement with them. On the other hand, we have parties like the socialists or the communists or, of course, the Congress, which are catch-all parties which speak the language of demos, and therefore they are the only legitimate. That is the only legitimate language in which we can speak, and that's, I believe, something that in a sense does not do justice to the complexity of politics in this period, where the question of language, caste, and of course religion are absolutely central, right? So I just wanted to underline these difficulties and finally ask Sandipto, the central concept that we are working with, the idea of transformational constitutionalism. How is it different from Granville Austin's old idea of social revolution? That was something that puzzled me right from the beginning of the book. That is central analytic for you. So I really wanted to understand, how is it really different from Austin's famous term? Thank you.
Thanks, Anuj. And I think I'll leave for Sandipto to answer that when we come back to him at the end of the conversation. And in terms of order, I have Arudra, you're up next. We have time, so there's no worry about that. Just again to flag the ordering for the viewers. So after Arudra and Aparna's contributions, we are going to have a Q&A, or well, I'm going to hog that Q&A rather to open the floor for questions to Sandipto and also between the panelists, because you don't get these opportunities to have these discussions very often. And it's a fertile ground to have, the opportunity to explore ideas that you might be having or pursuing in your independent space. And so I would love for that to happen. Yeah. Over to you, Arudra. Thanks.
Okay, thanks. Thanks, Abhinav, and thanks, Sandipto. So I'll say in the limited time I have, two things I liked about the book, and then two criticisms I have of it. And the criticisms you'll see in many ways align with what Anuj just said, but maybe from a different kind of direction. So I think what I like most about the book is that it's not a hagiography of the Constitution. It's a critical book, and we live in a time of hagiographies. So it was kind of a breath of fresh air to have a critical take on the Constitution. I also like that it was more explicit than, I think, recent discourse on the Constitution about the connection between the Congress and the Constitution. And you quote this speech, I think Dr. Ambedkar's last speech to the Assembly, where he thanks the Congress Legislature Party. Without you, we wouldn't have known what would pass in the Assembly and not. So it was really important. I think that kind of history of the Congress, and I'm not saying this, by the way, I'm saying this from a point of view of criticism both of the Congress and of the Constitution. I think it's very hard to decouple the two in this period. But we live in a world where the Constitution, at least, is sort of venerated on all sides. Nobody is there saying that it's maybe a problematic document, and yet there's no shortage of criticism of the Congress Party, or wishing to have other sorts of stories of origin for the Constitution. So those are the two things that I liked about it. But my two criticisms, one is kind of historical and one is analytic, stem from the same point. I think it's great that it's not a geography of the Constitution, but it seems to rest on a completely uncritical vision of the Congress at its best, or a vision of the anti-colonial movement. It seemed to me you were telling a Congress story of decolonization, or at least of the anti-colonial movement, which has essentially two central elements. One is sovereignty is what matters most, Purna Swaraj, anything less than sovereignty is giving in to the British, not, and second, in the service of sovereignty, extra constitutional politics of the street, satyagraha, civil disobedience, that's the thing that in the Congress narrative of itself is what's venerated. And in your book, this comes up again and again, this fear of not wanting to go back to that extra constitutional politics, which I think for you see partly as a one form of disappointing the promise of mass politics. So I think the central historical question I have in this, again, compliments what Anuj said, is that I don't think that's, I think one has to go beyond that kind of uncritical view of the freedom movement and what it stands for. There are lots and lots of political actors in this time, especially the 30s and the 40s, who would reject this completely. Ambedkar famously one of them, Jinnah another. Anuj mentioned Punjab and Bengal. We don't, because of, after partition, we don't think of the Punjab and Bengal political life is sort of part of Indian political life, but it's extremely different and not Congress provinces, Unionist Party and the Krishak Praja Party. So one point is many people disagreed and articulated in very sharp terms. So since we're on the term of Ambedkar, there are lots of people who say things like don't go with the they make a distinction between freedom of the country and freedom of the people of the country. In the 40s, people are saying this all the time. Don't believe the Congress. They're in favor of freedom of the country, but the people of this country are not going to be free for a whole bunch of reasons. Caste, class, to take one kind of example. So that's the first point. And I think when we buy the Congress line on this, we are essentially denying political agency to lots and lots of people in this period. I think that's a historical mistake. The second point is that, and it follows from the first, if you think about the pre-1947, the pre-1950 Constitution, the Government of India Act of 1935, that really does give political agency to many of these voices. And they want that agency, they use it to, for anti-Congress party ends. Not everyone is happy when the Congress assemblies, resign around the Second World War. I mean, again, the point being, there's a version of telling the story of the anti-colonial movement where anyone who's not part of the anti-colonial movement, as defined by the Congress, is out of the pale of the kinds of histories we want to sort of appeal to in thinking about ourselves. And I think this liberal, the liberals, the constitutionalists, the Ambedkarites, all of these people are very much part of that. And I think we can't ignore them. One problem with the last historical point, which is that if you read these people, they're extremely worried about universal suffrage because they're worried about majoritarianism. It's very explicit. It's very explicit with Jinnah. You have a quotation, in fact. So I was surprised because you note these things in the book, but then you don't carry them. You have something, where Jinnah says, yeah, of course, Gandhi is going to be in favor of universal suffrage because he has more people than I do. Ambedkar has similar kinds of fears. So, when we talk of universal suffrage as a marker of the growth of democracy, if we don't bring in these sort of question marks or these doubts, we're going to elide, I would say, in fact, aspects of Indian constitutional history that have come back to bite us now, in terms of, I would say, inadequate safeguards for minorities, for instance, at the electoral level. So that's the historical point that I think you've traded a hagiography of the Constitution for a kind of hagiography of the Congress in its, or sort of, it seems to be presupposed. I don't see much criticism of the Congress in this Gandhian mass mobilization avatar. But that leads me to the third point, which is really the frame of decolonization, the connection between the anti-colonial, decolonization, and the post-colonial. If the anti-colonial is identified with the Congress party, and if there might be many critiques one might give of the Congress Party in its heyday, in the best bits of the freedom movement that you appeal to, then maybe the anti-colonial is not that great a resource, even conceptually, forget historically, in thinking about how to critique the constitution. You want to go and say, look, these guys were great, but the problem was they weren't anti-colonial enough, or they didn't appeal to that anti-colonial energy that they had in deciding to, the constitution for the new country. And Gautam had, similar kinds of ideas and say, we're missing out this resource, this intellectual resource. But I would think that it seemed to me increasingly for a bunch of reasons, not just for reasons connected to your book, that the resources of the anti-colonial and the decolonial actually are, they actually narrow down the scope of things one can think about. Suppose we did away with that terminology and we just asked, for instance, how democratic is the Indian Constitution, or how good a job did it do at the task of democratization? I think that would be a more fertile kind of a window to ask the same questions you're asking, because these questions about whether it's fundamental rights, limitations on state power, whether it's on questions about protections of minorities against tyranny of the majority, questions about centralism or federalism. I mean, these are the bread and butter of democratic thought, and we don't need to engage. So I actually think, yeah, it's we end up going down lots of side paths that we don't need to, because we're too caught up with with a certain version of the freedom struggle and its possibilities. And that would be my fundamental critique of the book. Partition doesn't really show up. One could tell with the same facts. The great failure that's partition, for instance, which is not a failure and this goes back to Anuj's point about the imagination of the nation. So I would actually say, is it possible to tell the story of the Constitution that centers the Congress as a historical actor in what it did in these years of 46 to 50, but allows us scope to criticize it as a historical actor in the years leading up to it? I think that actually opens up new voices and maybe new concepts. So thank you. That's it.
Thanks so much, Arudra. And just to sort of riff off of that idea again, I think that's such a fertile ground for study, like research historically as well, because the idea, and I remember this from Granville Austin's book, the archives of the Congress Legislative Party's contributions not being accessed, and I don't believe they've really ever surfaced. But you don't know whether that somehow gets found, because I remember reading Ornit Shani's book, How India Became Democratic. She mentions as to how a particular archive was just misplaced for several years, and you never know, what if we get access to that material, and then it will really refine the understanding of what was being discussed parallelly in terms of what was going on in the Constituent Assembly, outside of the Constituent Assembly itself. So that's really interesting. Aparna, thank you so much for your patience. Floor is yours.
Now, one of the joys of going and the pitfalls of going last is that many things that you want to say have already been said, but the joys of it is that then you can focus on a few key things. So, I mean, this is a very rich book, and there's so much to engage with and threads to pull on. But I'm going to resist that temptation and pull on two that have not been addressed. Some of the others may come in as part of my comments, but I'm going to focus on the people and rights. Of course, a central theme running through the book is the relationship between the people and the Constitution, right? They are an absent presence. They provide the life force and the legitimation for independence and constitutional self-determination. But at the moment of independence, except for these formal words in the preamble, they are distanced from the Constitution. That's Sandipto's sort of argument. And Evidence of that is that the Constituent Assembly itself is not elected on universal adult franchise, though that had been the demand of the Congress party itself. And in the assembly itself, when they are invoked, they're not invoked as authors or as agents, but either as passive masses on whom the state has to work its transformational agenda, or as threats to the constitutional order, that it's an explosive force that they have to be contained. And so Sandipto's general claim is that the constitution is then drafted from the point of view of the anxious administrator, who has to administer this population and govern this population, rather than from the point of view of rights-bearing individuals. And one of the examples that you give is of how Part 3 of the Constitution, the rights provisions, were framed, which talk in the same breath of rights as well as restrictions, freedom as well as repression, right? And your argument is that the fear of disruption of the transformational agenda through the rigidity of rights and the explosive power of mass mobilization is motivating these design choices. So you say, and I'm quoting, in my reading, the fundamental rights were disciplinary. Their function was to facilitate and curate the incorporation of the masses into constitutional domains of politics. Or in other words, essentially the claim that you're making is, unlike liberal constitutionalism, where the state is constrained and so that the citizens may be free, under the Indian constitution, you have an inverse of that, where citizens are constrained so that the state may be free, right? And it may be free to pursue its benevolent, quote unquote, benevolent agendas. And that really is the key question about state power, about the way in which state power is conceived of, the way in which state power is justified and legitimated within the constitutional discourse. And I think that's what Gautam at least was pointing to, that the continuation of those justification, those discursive terrains have led us to a moment where criminal lawyers like Abhinav lose more than they win in courts, not necessarily because we don't have rights, but because we have rights that are justified in the way that they are, right? I have a set of questions about this framing, which are, I mean, just open curiosities at this point, because I wonder to what extent the legal form really has determined the possibilities of post-colonial politics, right? And is it so much about the legal form? Is it about discursive norms which would have existed with or without these legal forms? Is law overdetermined is law overdetermining your account of post-colonial politics? That's really the question that I'm sort of getting at by asking a set of questions, right? And I don't have an answer to this. I'm not coming at it from the point of view of having an alternative viewpoint. These are open curiosities. So one was, of course, are these design questions really motivated by single impulses? Or are they multiple things? Are they rooted in multiple worldviews? The authors of the Indian Constitution, by that I mean the actual authors who are doing the drafting, are also rooted in multiple worlds. They are rooted in the world of Indian society and marginalization. They're rooted in the liberal legal world of liberal legality. They are lawyers or administrators. So they inhabit these multiple worlds, and they're bringing all of those worlds together to the extent I know how, some of that complexity, for your argument to shine through, some of that complexity sometimes has to be given a go by. But I wonder to what extent, to the extent that the story that you tell is a story of how it is the threat of the masses that is shaping these rights and the configurations of state power. To what extent is it unicausal, right? So that's really the question. The second question that I'm left with is, what different forms would the design of the Constitution or its future trajectory have taken if anti-colonial mass mobilization had been configured into the Constitution? And I know this is not a project, you're not giving us, this is not a design template of how to design an anti-colonial Constitution. But I think the reason why I was left with that question is pretty much for the reasons that I think both Anuj and Arudra have pointed to, of the multiple meanings of coloniality and therefore anti-coloniality, decoloniality. I wasn't really I couldn't really figure out what you meant when you said that anti-colonial mass mobilization was absent in the constitutional configuration. Now, it was present in this negative sense or negative sense in the sense that it generated some different distinct design forms. But your argument is that what they did was they excluded anti-colonial mass mobilization or ideas born out of anti-colonial mass mobilization. And so I just wonder, what would a different articulation of rights or articulation of claim making, even if it's not in the language of rights, look like in this alternative universe? So I saw two arguments that came through very clearly, but I wasn't sure if there was something else to it. So the one argument that you make is that if the Indian Constituent Assembly had been elected on the basis of universal adult franchise, the very electoral, the politics around elections would have ensured that there would be a different idiom of constitutional politics that was present. People would have made different sorts of claims, particularly given the importance and salience of the fact that this was a constitution that was being framed, and that might have changed the nature and content of rights, right? And of the constitution as a whole. What are the kind of claims that found their way into the constitution? What are the kind of things that were kept out, so on and so forth. In that context, I was thinking of, and I've asked you this question before, is Rohit Dey's and Onichani's new book, where they argue that even though the framers wanted to keep the people away, the people wrote themselves into the constitution. Again, this is the question that I've asked you before. How do you see your work in relation to this? So I wonder if you have a thought there. But the second way in which you sort of expressly articulate what encoding mass mobilization would do is that not all of the repressive elements of the constitution may have found place in constitutional design. And some of those repressive elements, like preventive detention, I might agree with you. But frankly, and this again goes back to, I think, some of the points that Anuj and Arudra were making, by the time this provision is being debated, right? Article 22 is being debated. The specter of mass mobilization before the framers is not that of anti-colonialism. It is of partition-induced violence. And so I wonder if, even though you recognize in multiple places that not all mass mobilization is emancipatory, whether there is a sense of romanticization of mass mobilizations, and how that might sort of impact constitutional design. So I think that was a question that I was left with. And finally, I think to the extent that you see limitations on rights as somehow expressing and articulating these repressive tendencies in the Indian Constitution, again, I was left unclear about what the alternative was. To the extent that you're citing Constituent Assembly debates for this part of the discussion, there's a sense in which rights could be absolute, but they were really watered down. But I think this was a concern that was raised in the Constituent Assembly and rejected on just purely, liberal legal grounds, which is that even where rights are articulated in this context, the US was the paradigmatic example, where rights are articulated in an absolute sense, it is judges who have crafted exceptions, because rights need to be worked in practice, and in practice you will need to make some kind of accommodations. Classic example being freedom of speech versus someone shouting fire in a crowded theater. So you will need to have some limitations and constraints. Do we leave it to judges? Do we as framers put it in themselves, so that there are clear bright line rules on when rights can be limited? And I see this. So this was in some senses also an institutional question. Again, these are things that you recognize yourself in the book. Again, this gets me to the point that that trend that you notice of trying to control the population, right, and control and discipline the population is obviously there, but there are other constraints as well, right? So I just wonder to what extent, when in rights discourse there is a framework, there's this idea that when you have a hammer in your hand, everything looks like a nail. And I'm wondering to what extent this is a hammer and nail question. There is I think, final two points very quickly. There is this idea of this sort of that missed opportunity, right? That's a running theme. That you say, for example, under the new constitution, the masses could vote, but there were no structures that enabled them to emerge as a collective agent outside of electoral aggregations. Again, the question that I'm left with is, what could those possibilities be? And it might be the failure of my sort of legal imagination, but I'm not being able to see that. So I just wanted to see if you had ideas in mind. And that led me to my absolute final point, which is, should the people be incorporated? And that's potentially disciplined by the logics of the constitutional order. Or is it better to remain outside as an extra constitutional force that serves as a disciplining power on the state? Right? So to what extent is, if you want to bring them inside, how will you escape the disciplining power? Is it possible? Again, what alternatives are there where you can bring in the people without the disciplining power? So those were some of the questions that I was left with. I mean, I have many more, but I'm going to stop here, and hopefully we'll have the chance to have a conversation. Thanks.
Thank you so much for that, Aparna. And I think what I have in mind is, why don't we have some time, right? So we have around 25 minutes left. And I think a lot of the speakers have left, questions, thoughts, comments in terms of the themes of the book. And that's fine that they're not directly related to some of the issues that I would want to, sort of flag entirely, because I think they're still really important, because they come back to the idea of constructing an argument which is still useful, let's say, across contexts. So constructing an argument on decolonization, constructing an argument on continuities. So I think all of those questions have, great resonance for what we are discussing here at the MCLR as well. So I had thought that maybe, Sandipto, we could just give 10 minutes more to, respond to whatever questions or themes that you would want to respond to. And then maybe we can see where we are left with in terms of time, and take on panel questions or questions that come from outside the panel. Does that sound good for you? Okay, great.
Yeah.
So I'll just...
I don't think 10 minutes is enough, but I'll give it a shot because thank you for this. Really, I don't, because they're critical comments, but they're justifiably critical comments. I think these are productively critical comments, because it's not about mistreating of the book, or not about, bringing other things I could have not written about. It's actually a genuine, engaged debate. So I'm very happy to get the opportunity to sort of have that conversation. Though I would say this, like normally when I talk about this book, the critique which comes is that I'm too critical of the Constitution and the Congress and India. So this is refreshing to think, not refreshing, but at least interesting to see that, both Anuj and Arudra think that I'm too generous to the Congress or the Indian nation state, for that matter. So let me sort of try. There's too many specific things. So maybe I'm just thinking when we were talking, just that maybe there's a couple of methodological points to answer these, and there's a couple of substantive debates, I think, to engage in. The methodological point, I think, is important because all of this is said, the justified comments about that there is a richness of Indian constitutional imaginaries, political imaginaries at that time, all of which I do not deal with, right? Including questions about, from the princely states, from other different groups, of which I think there's been more and more excellent historical studies has come out of that. So the first, and it might sound like a bit of a cop-out, but actually I genuinely mean this. I think just that I'm not a historian by training, but also this is not a book of history in the sense it's not supposed to give an extensive coverage of all the various things. I'm a political theorist, and I'm interested in making some kind of a political point and a pattern, which means I do have to operate at a level of abstraction, right? Because without that, what you get is going to get lost in the details of this, and you don't get a kind of an argument, so to speak. So while I think that's a very important task for those who do it and do it really well, much better than I would be able to. I don't do, in that sense, of archival work. There's nothing in this book which, as I've discovered, is an archive. They're mostly, working with material already available. So that's the kind of, and I think that's some of the questions about, these complexities and these multiplicities. But that doesn't really get me off to which ones do I choose to work in abstraction. I think that's where I would come to the question of the Congress and why the Congress plays such a big role. And it's actually the opposite of what I think Arudra was suggesting. It's not because I do think Congress is the exemplary anti-colonial party. I do think Congress is in the history of decolonization globally, it is the most popular anti-colonial party in history, and it's not something to be dismissed entirely. But the reason Congress interests me is because they are the party of government following post-colonial rule. Because if I'm starting point to understand the making of post-colonial institutions, this is the party which will do that, right? It's not a defense of Congress's representational claim. I try again and again to basically say, in the very first chapter, I argue that the Congress history would be there are two parties. There's the colonial state and there's Indian people led by the Congress. There's nothing else. And I want to say that for me, the real sort of action is really between the Indian people and Congress, right? To what extent they can or cannot represent them. And that is really, I think, what shapes the nature of the anti-colonial movement as opposed to the British versus Congress debate, which I think is the general story we get. It's really this debate. Congress's struggle to, in some senses, be able to talk for the masses, while the masses want to speak in many, many more voices or in many, many forms than the Congress is comfortable with, right? That is the nature of the debate, even after, especially after Gandhi, because that's when they really open up. And this is what Gandhi keeps coming back to again and again from the very beginning, from Chowre Chowra onwards. This is the issue with the Congress. So the Congress is, I have no, in that sense, defense of Congress' representational claim. What I want to do, nevertheless, is say that that's the one which triumphs as the post-colonial government. So what is the form which takes us from this to that, right? And that requires this particularly fraught, and I think in some senses, tension-ridden, contradictory relationship with popular politics, right? Where one which you both have to kind of claim to embrace and represent, while it deeply kind of destabilizes your own position as social and political elites. Right. So that's the kind of, I think, the question regarding the Congress. But there's a more deeper, I think, question, the deeper serious sort of critique in both Anuj and Arudra's point, which I can sort of maybe present in two ways. I hope I'm not being, sort of unjust to your critiques, because I think there's one argument which is to say that I take the ethnic question, so to speak, too lightly, right? I just sort of put this on the British state, divide and rule, and that's what it is. I don't like it. Let's move around from that to something else. I want to say, and this is Anush's point about the mass. How do I define that? This is, I think, Arudra's point also about thinking about the minority rights question and so on. And to that, I would say this, right, which is I want to historicize this particular moment. I think there is a way in which questions of sort of minority rights or ethnic things are in some forms often reified. They're taken as a given, right? That's not to say that they're not important. They're deeply important, but they're constructed. They're constructed by particular political and social forces in particular historical context. It's not means it's a conspiracy of the British state. I actually mentioned that British did not invent divisions in the society. They existed way before the British. They still exist now, right? But what mattered to me is not so much the descriptive level of what is Indian society, how many divisions there are, but what is the political valence of those divisions. So Mahmood Mamdani has this thing that the real question is, how do social questions, right? Social facts become political facts, right? So the fact that I am, of course, it means something pretty real to be born a Muslim in India, let's say 1930, right? But what does it mean politically? What does it mean in terms of how I appear in the public sphere, how I understand myself in the institutional space? And that process, I want to argue, is not given. Because if we agree that that's given, if we agree with the Jinnah quote, which Arudra was quoting, which is Jinnah when he says that, 1/4, Gandhi has 3/4, I have 1/4. If we take it as a given, there is no way you can have democracy with that, right? If you give up on the idea that Muslims will always speak as Muslims, Hindus will speak as Hindus, Dalits will speak as Dalits, and there's nothing else possible, which is the basis of the colonial political theory about all colonized countries, that the colonized people can only represent themselves from their social location, nothing else, right? They can just only give voice to whatever their given social location is. There is no democracy possible in that. So the part of what democratic movements, mass movements do is allow people to construct and appear in the public, appear in political, which is constructed through the terms of that movement, right? Doesn't mean that's a good construction. Can we have bad? You can think of, you can be considered a Hindu nationalist frame. You can consider the Muslim nationalist frame. You can consider Indian, which is already kind of has, like all sorts of illusions and repressions happening, sure. But nevertheless, it's a construction, it's a political project. Once we agree to that, then we can you don't have to take this as a given, as a fate, which then only question remains, how do we manage it? How much rights? How do we stop the state from doing this? Majoritarianism and so on. But how do we actually transform that? And my argument was that anti-colonial movement, mass movement, and there I actually speak a lot about the Quit India movement, which is not a Congress-led movement. The whole reason the Quit India movement for me is important is because the Congress leadership goes out of the scene on day one, and it becomes a much more bottoms-up movement, right? And what that allows us is the new kinds of affinities. Might be local, might be across, caste, maybe within caste religious things, maybe based on class. All of these forms arise there. None is given, none is sure shot, but they arise. All that tells us that there is a potential for this kind of transformation possible, right? And so all I want to say is that the nature of the institutional and architecture, which separates itself from any popular movement, bad or good, right? There's no, and I agree with Aparna, I want to say that, I do say that in the book, but I want to say it again, that there is no romance of this great one-shot mass movement. That's never been the case in history. Never been the case in history. Mass movements are conflictual, they often get to bad outcomes and so on. But just to say that if we never try that, all we end up is arithmetic. All we end up with is given numbers, and the question then becomes, how do we add them up, right? So so that's the kind of point I wanted to make, not to at any point to diminish that argument about the significance of ethnic divisions in India, but more to say that is there a way to sort of politicize them differently, give different political balances to them, right? So that's the point. And on that, under the question of what Arudra was saying, why not take something like a democracy or minority rights as rather than anti-colonial as the kind of reference point? That's I think a very important question. And I want to say this, right? When you say democracy understood as what? Right? Because there's one way we can see this kind of normative concept, what democracy means, which we can take and say, okay, how does the Indian Constitution measure up and down on that? Right? Or we can say, what was the resources of democratic thinking generated by history internal to India, India's own anti-colonial history, and see how we measure up on that term as an immanent thing. Because the other thing, what we get is a very typical sort of form in which we sort of critique, third world countries don't have enough democracy because they have less liberal rights, they have less, free and fair elections. That doesn't give us a critique which is internal to our own history, because that always gives us, oh, that's like a Western. I want to do is a critique, I think, in some senses, of the Indian Constitution, of the Indian political order, of the Congress as a governing party, which is internal to India's own anti-colonial history. So that's what I mean. You don't draw from those resources enough, because I do think the anti-colonial movement is a resource for all its faults, right? It's an extraordinary mass movement which is fighting against pretty, very strong force for self-determination, an idea which, for all its faults, is extremely powerful, right? Now that we don't fully realize that is the question which I want to know how and why. Right. So that's why I think I didn't want to get into a kind of the critical resource I want to draw from was internal to its history, which has, of course, all these other problems where there's some levels of abstraction happening. There's some things I'm, drawing from, constructing, framing. But that was the kind of goal. There's more things I want to say, but of course, there's not enough time. So I'll just end with one very important point, which Aparna raises, I get a lot, which is that what would the counterfactual thing even look like, right? So, the answer is not to give a model of this. It's deeply fraught. What I'm more interested in doing is that using that absence or that, that kind of deliberate distancing, right, as a way of critiquing and understanding our own conditions. Not so much to say that, this is other path available, because I think counterfactual or speculation, there's a term I use there in the book, it's called like sort of daydreaming of the left, whatever, right? Like, we only had that. I think that's particularly useful as a political project or a scholarly project, right? It's what I'm rather interested in doing is understanding, thinking about the current the condition that we have through this critical resources drawn from, these acts of distancing, rather than the, that other path where would have gone with that, right? Because that's really impossible to answer honestly, fully, because it's so fraught. But that's, I think less helpful as a sense of the political analysis for me. But again, I've not answered a lot of the things, the important things you brought up, but because of the time.
No, I think you still managed to get in quite a hefty bit. But In terms of follow-ons, would Arudra, Anuj, would either of you want to? Oh, sorry, Gautam has his hand up, so he's beat both of you to it. Yeah.
I mean,
So
I'm happy to
Gautam,
go later if there's some direct sort of, because, I think there's more of a conversation responding to some points they'd made. So if they want to speak first, I'm very happy to like go later, because mine's on a different point.
Anuj is vigorously saying no.
No,
I'm happy
Gautam,
to
please go.
say,
Gautam, please go ahead.
yeah, I
No, I
would,
mean, yeah, I think just on the Rohit Day and Orange Shani book, which I recently read and I enjoyed very much, and I think it's interesting because in that book they set up like two sort of books that are sort of foils to their project. One is Madhav Khosla's most surprising democracy, and then the other is legalizing the revolution. I can fully understand why they consider Madhav Khosla's book to be, a foil, because there is a direct clash of arguments there, in the sense that he argues that it was an elite top-down project, and their point is that it was actually, in many ways, a popular project. But I was very surprised why they seem to be so intent on setting up legalizing the revolution as a count, as well, like as like a clash between these two books, because I thought they complement quite nicely, because the point that Rohit Day and Shani make is that there was a groundswell of popular mobilization around the constitution, and so we always think of the constitution as a top-down project, but there were various ways in which the people came in, right? But Rohit Day and Shani also concede, as they must, that ultimately what the people said is not really there in the constitutional text, right? And so yes, they had a role to play in the process, and we learn a lot from their book about how that happened, and in that sense, it's an invaluable book, and I think it's really helpful also for practice, because you actually have an anchor to say, look, we have a history of participation, and so therefore we should be informed in interpreting the constitution by the history. So I see a lot of value in that book. I think it's a great book. But the point that legalizing the revolution makes is that finally the document you got was one which was obsessed with the state, and where the administrator was the central figure. This is the point he makes at somewhere in the book. I've forgotten exactly where, but the central figure in the constitution is the administrator, right? And so I find these two projects to be very complementary. One tells us that the people really came in. The other tells us that they did come in, but ultimately they weren't listened to in what we finally got, and that's why we are in such a bad situation right now, because we didn't listen to what we were being told. Not we, but like the framers did not listen to what they were being told from Manipur, from like Mizoram, from like the scheduled like districts, from like Punjab. They didn't listen, right? And that's why we are now where we are. So yeah.
So in fact, I'm reading that book right now, and I had the same thought while reading it, that this is exactly that is the development of that argument, that it's not going into the document, and there are so many small examples that you can use, and I came across one very recently in terms of how continuing preventive detention became such an important thing for the Constituent Assembly, but it wasn't actually the Constituent Assembly, and this is just another perspective, and then I'll flow into a question. But the other perspective that I wanted to add was developing on the idea of the administrator. It was how important the administrators were in real time in that drafting process from 1946 to 1949, 1950, where these government servants of different, like ultimately, Sir B.N. Rao, you can look at HVR Iyengar. These are all really storied names in the process of like the framing of the constitution. There are several other examples, but ultimately they are creatures of government, right? They are fully embedded within a civil service that is again a creature of history. And you see that in the notes that they are coming up with. You see that in their contributions to what are the issues that the government is dealing with at that point of time. And I think that's another third perspective that gets added to what is there in this book, what is there in Rohit Dayan or Nichani's book, as to how that structure was being protected by all, from all sides, right? It was in fact all of the political actors who had access to power were very interested in making sure that that structure was protected, and effectively they were fighting for their share of those civil servants, right? At the time of partition, you have literal like memos, angry memos being exchanged. You haven't given us our share of those really prized possessions, which are the civil servants. And I think that's another perspective that will get added maybe, in the next 10, 15 years as the archives get more and more accessible, as to how important those voices are in that, in that period of these countries, coming to the fore, and how that then gets carried forward in how the countries are governed, because that project of governance is so critical in how you proceed. So that was just one contribution that I wanted to make in terms of the conversation. But beyond that, I think one theme that we didn't discuss too much, but is there in the book, and I want the panelists can take it on, the idea of the court, right? So afterwards, what happens? And there's the book also does talk about that, and which I found really interesting, which is that how the lawyers and the Supreme Court of India sort of tap into an entirely different culture altogether, which I found extremely fascinating, which is that it's not the constitution, it's not the constituent assembly's ideas, but hang on, we're going to tap into common law, and we're going to tap into a totally different wealth, like a reservoir of ideas, and ideas that are again formed by politics, right? So the common law is not, I mean, it is again a very historically situated construct. So that the Supreme Court goes there, and I think that's again a thread that is waiting to be developed, as to how well that's led to a completely different line of development of law, when it comes to criminal law or even constitutional law for that matter. So I was wondering if, Shandipto, you could, maybe elaborate on that theme a little bit, and even the rest of the panelists, as to how, what has been the role of the court afterwards, and how, how Shandipto's book argues that, there's a dissonance there, and there's a break there as well. And so I would love to hear your thoughts on that, because the Supreme Court is, as has come out to be as important an institution as it has in how we understand the Constitution.
Sure, I'm happy to, but I think Aparna wanted to say something.
Yes.
Okay, no, very quickly, because I raised that Rohit De Onichani point. Let me just say, I think this is what I see their argument as being. It's not so much about whether people outside the assembly are being heard within the assembly, but that it creates a particular culture of constitutional claim making where people see themselves. Now, we may agree or disagree with it. I'm just stating in their absence their argument, which I thought is what runs in some senses counter to Shandipto's argument, that people start seeing themselves as authors of the constitution, that, or at least to the extent that they see themselves as legitimate claim makers on the constitution, that their voices should be heard, and that in Rohit and on its sort of account shapes subsequent constitutional politics, right? So the question that I had for Shandipto was precisely that in some senses, in your account, the anti colonial mass movement either gets the masses get demobilized, or they get individualized, and they get individualized, or they become completely extra constitutional. And the claim that Rohit and Ornit are making is that it's not an inside outside thing. It's straddling that, right? That you're from the outside, you're writing in, you're speaking in, and you make yourself heard through these mechanisms. So I was just wondering what your take on that was. But I think just to Abhinav's point about the post-colonial state, and again, I'm left with the question of to what extent is it sort of liberal? So there's a way in which liberal legality and the transformational agenda are pitted against each other, both in this book but also in the literature more broadly. And I was just thinking about the conditions of freedom and unfreedom under these alternative imaginations. So Gautam was talking about A.K. Gopalan. I was thinking of Anwar Ali Sarkar, which is the first case on Article 4, one of the first cases on Article 14, equality. Such a central question, both before the Constituent Assembly and in the pre-constitutional moment. And they deal with it in the most banal way possible, right? As formal, equal way that they can, right? Except for Vivian Bose, who specifically says we should tap into this longer history. But what they do with that is so fascinating. Here are a bunch of lower caste Muslim men, right? Oppressed caste Muslim men who are waging war against the country, and they're communists. They're waging war against the country. They've bombed an airport. And the Supreme Court says, no, actually, this law that under which you were convicted was unconstitutional for the most banal, what would appear today to be the most banal reason possible. And so you are set free. Now, with all the vocabulary that we have at our disposal today about rights and all of that, when with the courts specifically trying to tap into, whether they do it well or not, but trying to tap into this long arc of constitutional history, so on and so forth, and locating themselves as a player in this transformative agenda. I can't imagine, and Abhinav and Gautam will bear me out, I can't imagine having these kinds of protagonists in any case before the courts today and getting the relief that these guys got. And this is why I'm asking, are we over determining the legal form in thinking about how how courts really operate as actors in this field? It is not at all about the legal form. It's not about liberal legality versus transformative agenda, so on and so forth. It is about what tools and specific ways in which the judges make use of it.
Thanks. Actually, this allows me to talk about both of the question, the law a little bit more. I just want to say this about the Rohit and Ornit's book. I haven't read the book. It's not available in America yet. I don't think it's out yet. I think it's complete around this month. But I've read the article. So that's why I was a bit hesitant to speak about the book, which I haven't read. But I think from the article, what I could say is, I think, and it's an important, I think, in some sense, it links to somewhat of the debates we had today as well, which is this, right? Part of it is an empirical question, which I think Gautam already articulated, how much of that gets in the Constitution. But the more interesting one for me is, and maybe that also links to what Anuj's question about how this is different from Granville Austin's book. Both of this is really about kind of conceptual, theoretical debates. So with Granville Austin's book, the difference I would have is that I think he has a much more sanguine or simple idea of what revolution is. I think he thinks, it is about transformation, it's done, it's seamless, there's no conflict. I don't think any of those things are true. I think it's conflictual, it's contradictory. I don't think it is realized. That's the big distinction between the project we have, the question, I guess, we frame similarly, but the answers are wildly different, right? And similar thing with Rohit on it, I might consider different the idea of what the people are, right? And I think they take what in political theory we'll call them like a civil society groups and their interventions in languages which are legible in legal institutional forms, right? To be the people. And I don't think that's the people. I understand the people to be the mass movement in a country where 80% of the masses were peasantry, right? Who are doing I don't see these institutions as standing in for the people. So I think that's a question about, there's a theoretical distinction, and that's not necessarily an empirical, historical debate. I think it's an important one to have even today, that how we understand popular politics or popular participation to be. So that's something, say, between something like a PIL, which is a very important mode, which I don't think necessarily is a popular intervention in law. See, so that's a theoretical debate. Again, I should hold out on it because I haven't read the book yet entirely. So, this is sort of a bit speculative in that sense. On the question on law, that's a big thing. I don't know how much time we have to talk about that, but I think to me that was quite an interesting thing, and maybe it answers Aparna's question as well. I think you're right, Aparna. I think this is a master key for understanding all Supreme Court cases, right? And that's where I think the question about what are the right variables I'm using are overdone. But I think I was more interested in understanding the difference of the language of law and legality, which the Supreme Court draws from, and the language of anti-colonial politics. And I think the way, to me, again, it was interesting, again, at a level of abstraction slightly, is that the way the Supreme Court understands what decolonization is. And for them, decolonization or independence is really now their ability to finally become equal partners in the world of common law. Because under colonial rule, they would draw from that. But because of the, undemocratic, extra legal, illiberal nature of colonial rule, they wouldn't be able to fully incorporate all those, incorporate Blackstone into their judgments. Now they can. So it's in a way, it's the idea of independence as a way of proper incorporation into the canon of common law, shared it now with the British and the Americans and who else, right? While the understanding of, I think, independence, which many of the Congress leaders and the planners had, was a way of transforming, breaking from this imperial world where we are in some kind of autonomy politically, right? Politically and economically, whether that be through like protectionism, planning, other forms, right? Creating distinction and autonomy from the empire. Well, this was an idea of incorporation in that. Again, this is as saying I'm saying it at all level of bit of abstraction, but to me that was really interesting. So because it goes away from this idea, which I think was quite common in the left-wing critique of the Supreme Court, which is that these are reactionaries, they're of landed interest, they're rich themselves. To I think understanding them, what is the language of law, the form of law itself does, vis-a-vis this project of planned social transformation. And that's why there was an interesting question for me. So yes, is it sort of give us a somewhat of a more essentializing theory of legality, which is in some senses, I think that's a correct thing. I think there are ways in which you can say you can distinguish it in cases and get to that why each case had this particular modality and so on. But I was more interested in looking at it like a broader picture of these two sort of parallel paths and parallel understandings of what independence from empire would mean, right? So that's the sort of short answer in law, because I see Arudra has his hand up as well.
Yeah, Arudra.
Sorry, this is not to say, actually, I kind of in a way lost my train of thought, but just on this point of courts, in relation to this moment, I just again want to insist on that distinction between freedom of the people and freedom of the country. And I think it's a mistake to think that colonial courts interpreting colonial law are not necessarily in service of defending the rights of individual people. And one archive that's worth looking at, and actually one needs to think about in terms of, and Chandra, this is in a way grist for your argument. If you look at the years 46 to 49, where the constitutional structure under which India is governed is the Government of India Act of 1935. But since 1946, you have provincial assemblies, Congress-led provincial assemblies mostly governing the country. You have a lot of executive judiciary fights happening in that period across the board. I mean, you mentioned other things, licensing, preventive detention, the works. One part of the story of the framing of the Constitution, which is not been written as yet, is the need, I think, for the constitution makers in their avatar as running the country to be able to get the upper hand on the courts. I think Gopalan shows that they win that. But I think I guess what I'm trying to say is the resources of colonial law are quite strong. They're quite strong in the case of preventive detention. I think even in the case of economic licensing. So think of Rohit's. I remember Gautam, in fact, at Rohit Day's book launch for his earlier book, The People's Republic. There are all these cases where the high court cases. The whole book is about all these high court cases of people appealing to the constitution for things like, the right to have a drink, for instance, in Bombay against prohibition. They all lose. So what's interesting is, they win in the high courts, where they're applying like pre-constitutional, common law, and then they go to the Supreme Court and they lose under the Constitution. So I think that there's a kind of resource that we again we deny ourselves if we take on the anti-colonial avatar and we think, look, that should be the thing that that should be the lens through which we see these battles. We, I think, deny ourselves a really important, useful resource in as far as individual liberty is concerned, amongst other things. But yeah, there's more to say. And by the way, again, I think we deny. You want to say, I don't want us to deny ourselves the resource of anti-colonial history or anti-colonial thought. I think there's something a little ironic about that because some of that resource of anti-colonial, that reservoir was also a universalist reservoir. They're not saying, look, it's for us. These are things that are important because freedom is important, or
yeah, absolutely,
dignity is important. Those are universalists in nature as well.
Absolutely.
So yeah.
The concepts of the aspiration are universal, but the form in which it sort of takes, it unfolds here, right? so the anti-colonial movement 20th century would not be the same, say, of a classic 19th century bourgeois revolution, which is often the historical resource from which we draw these conceptual tools, right? And so what democracy would mean there, what popular forms would mean there, right? Popular demands would mean there are different. But the only reason to say that is because I would say, it's not that because I want democracy in India in these forms. It was the anti-colonial movement opened up the possibility of thinking of people as political actors, as empowered, informed political actors, right? Because of its very nature, right? From all the party organizations, the forms, the conversations, newspapers, communications, all of which is the gist of politics, right? Was kind of spread out because of that, right? So it's not so much of the principles of anti-colonial movement, but the kind of political vocabulary and forms it generates, which is then, I think, moved away from. That's the thing that sort of, kind of interests me. And so in those terms, we can have, a critique or critical resources of that. Thinking of those, I just want to also quickly say it because I think I was just thinking while we're talking about this, like Anuj also made a very important point, which is harder to answer for me, which is that's why I should acknowledge that, which is that his point is that why are ethnic parties not the kind of mass mobilization I'm looking for necessarily, right? And I think the reason would be, again, to go back to this anti-colonial, post-colonial thing, because I think the reason, because there is this sort of collapsing of the social and political fact in that, right? Or not enough of a mediation of that or distinction between those two things, which seems to me too close to the colonial idea of political selves, right? So my critique of Muslim League is not from a secular point of view, but from the point of view which was not necessarily democratic enough or mass mobilization enough, that sort of just took for granted this idea that this is the only form in which a certain community can express themselves politically through their own representatives, right? So it's so that I want to make even that critique. But sometimes we critique these things on sort of secular liberal grounds, right? These are particular race, this. Those, I think, is not a good way to critique them. Like, my critique should have to be based upon the nature of anti-colonial politics and the kind of way they were trying to separate themselves from the colonial political descriptions. And so from that point of view, if I have any critique of those, and those are, again, I'm going to talk about the moment, I'm talking about Mandal, I'm talking about the moment of the, the formation of Indian, of the Indian Constitution. The Muslim League is a real entity. I think that would be, if anything, my critique of that. I think it's a serious and important question given the nature of Indian democratic life. So I want to acknowledge that.
Well, I have rather enabled overshooting what was a 9:30 deadline by more than 10 minutes, and I don't want to impinge on everyone's time any further. So thank you so much for what was an absolutely fascinating and engaging discussion. And I think the true marker of that is exactly in what Sandipto said towards the end, which was that, it's very enriching for the author to be here and to be part of conversations like this, because it then offers critique that you can reflect on and explore, see the ideas that are being drawn out in the book being explored and being fleshed out further, and that's what this is all about. And it's also really helpful for people who are interested in these questions of decolonization, post-colonial theory, especially its intersections with criminal law, because I think it throws up, especially the conversation that we had around the book, throws these questions up in much sharper relief, especially when it links to political and social identities, and also how you straddle all of these questions when you are deciding to confront state power, and also what does criminal law mean from that perspective, because the interaction and the interplay of criminal law and that aspect of power with social identities of individuals is, I think, something that's so criminally underexplored, especially in an Indian context. And further food for thought for whoever it is that will chance upon this discussion later on. So thank you so much again, and have a great evening, and have a great morning to those of you who are not in Indian Standard Time. See you. Thank you so much.